Hi, and welcome to this week's episode of the Case of the Week series, brought to you by eDiscovery Assistant in partnership with 𝐀𝐮𝐬𝐡. My name is Kelly Twigger. I am the CEO and founder at eDiscovery Assistant, which is your GPS for knowledge and education. Thank you so much for joining me today. Each week on the Case of the Week, I choose a recent decision in eDiscovery and talk to you about the practical implications of it. This week's decision highlights how easy it is to lose track of multiple copies of documents and not treat all duplicates the same way in production, and how that can lead to waiver of the attorney-client privilege, even where the parties have a 502D order in place. Now, a couple of announcements before we dive in. Just an hour after this morning's broadcast, I'll be joining my colleagues Brett Burney at NextPoint and Doug Austin of eDiscovery Today on a webinar about the latest in hyperlinked files. So Deja will add that link for you to be able to register if you're not already signed up. I think we have about 450 people attending, so that will be fantastic. Second, our whole team at eDiscovery Assistant will be at Relativity Fest the week of September 24th to 26th, where I'll be speaking on the case law panel again with David Horrigan and a number of esteemed colleagues, and as well as talking to the relativity scholars and mentors that week. So if you're interested in signing up for a meeting to chat with us while we're at Relativity Fest, please check your email for a link, or you can reach out to us at support@ediscoveryassistant.com. All right, let's dive into this week's decision. This week's case comes to us from the FTC versus Amazon.com Inc. matter. This is the second decision that we've covered from this case. This one brings about some very important points for us. This is a decision from August 1st, 2024, so just 3 weeks ago, from United States District Judge John Chun. Judge Chun has 27 cases in our eDiscovery Assistant database. And as always, we tag each of our decisions with our proprietary issue structure. This week's issues include FRE 502D, FRE 502B, redaction, in-camera review, instant messaging, waiver, attorney-client privilege, and clawback. Now, as I mentioned, this is the second decision we've covered for this case. The first one was episode 149, which you can go back to. To refresh your memory, this is a matter brought by the FTC alleging that Amazon is a monopolist that uses a set of interlocking, anti-competitive, and unfair strategies to illegally maintain its monopoly power. The FTC and its state partners say that Amazon's actions allow it to stop rivals and sellers from lowering prices, degrade quality for shoppers, overcharge sellers, stifle innovation, and prevent rivals from fairly competing against Amazon. Now, we are before the court on this decision on a motion to compel from the FTC, seeking to require Amazon to produce 17 documents. Amazon originally produced all 17 of these documents as part of the FTC's underlying investigation or in other investigations, and then clawed them all back, asserting privilege. Now, the FTC argues here that Amazon waived its privilege by producing some of the documents intentionally with redactions and by failing to promptly claw back some of the unintentionally produced documents. In terms of context, Amazon has produced more than 1.7 million documents across 3 separate FTC investigations into Amazon. The 3 investigations are called the Dark Patterns investigation, which led to this case. And the FTC also investigated Amazon in 2 other unrelated matters referred to here as investigations 1 and 2. Now, the 17 documents at issue fall into 4 categories, as there were multiple copies of the same documents. There are numerous facts about each category of documents that you'll want to dig into, and it's just too much for us to cover here today. The first documented issue was what's called the May 4th memo. Amazon produced 2 redacted copies of the memo during investigations 1 and 2. The FTC used the memo at a hearing during the Dark Patterns investigation with no objection from Amazon, and again a year later, during which time Amazon's counsel did object and sought to claw it back. The second document or set of documents was the July 14th memo and presentation. Amazon produced 6 copies of the memo, both with and without redactions in investigations 1 and 2. It then withheld the memo as privileged in the dark patterns investigation and then produced a redacted version in the dark patterns investigation. All 5 versions of the presentation were produced without redactions, again, in the dark patterns investigation. The third document was IC-37, a document which was prepared for a meeting among members of the Amazon Prime team on May 10th, 2021. Now, Amazon produced IC-37 without redactions in investigation 1, clawed it back in the dark patterns investigation, and then produced a redacted version. Then in the litigation before us, Amazon clawed it back again and reproduced it with additional redactions. The fourth set of documents included chat messages in IC9 that the FTC identified as potentially privileged to Amazon in the dark patterns investigation. So a situation where the FTC received the document, told Amazon they thought there was potentially privileged material, and allowed it to take action. Amazon clawed it back and then produced it with 13 messages redacted from the chat. The FTC argues that 10 of those redactions are improper and seeks an in-camera review from the court to make a privilege determination. Also in that set was IC-40, which Amazon produced in investigation 1. The FTC used that document as an exhibit during a hearing in the dark patterns investigation, after which Amazon clawed it back. A similar fact pattern occurred with IC-37. The FTC argues that by producing documents with redactions and failing to take steps to promptly claw back documents, Amazon has waived any privilege in all of these categories of documents. Now, also of note is that the parties did enter into an order under Federal Rule of Evidence 502D for the litigation, which provided that, quote, pursuant to Federal Rule of Evidence 502D, the production of any documents, electronically stored information, or information, whether inadvertent or otherwise, in this proceeding shall not, for the purposes of this proceeding or any other federal or state proceeding, constitute a waiver by the producing party of any privilege applicable to those documents, including the attorney-client privilege, work product protection, or any other privilege or protection recognized by law. So that's the order that was entered into the litigation, and that's going to be important. So let's move to the court's analysis on these particular set of facts. So the court's analysis begins with the principle that waiver is the issue when determining whether a clawed back document is privileged, and that generally a party waives privilege by producing a document. It also notes that Amazon has the burden of demonstrating privilege as the party asserting it. The court looks first at the applicability of the FRE 502D order, under which the FTC argued that it only applied in the current litigation proceeding and not to the earlier investigations. And the court agrees with the FTC, stating that the 502D order applies only to, quote, documents produced in this lawsuit and not documents produced in the pre-suit investigation, close quote. That's pretty much a big blow to Amazon here, but it's important to note that language, and we'll talk about it in the takeaways. Now, neither party cited to case law as to whether or not 502D applied to pre-suit investigations, and the court looked to the definition of a proceeding in Black's Law Dictionary, noting that it does not apply to documents produced in the underlying investigation or to other proceedings. So with that issue out of the way, the court then looked at whether Amazon made reasonable efforts to rectify its production error under Rule 502B, which is now the applicable standard. That rule requires 3 steps to find no waiver. 1, Amazon's disclosures must be inadvertent. 2, Amazon must have taken reasonable steps to prevent the disclosure. And 3, Amazon promptly took reasonable steps to rectify the error. The court started first with whether the disclosures were inadvertent, and the court found that a party's having produced the documents with redaction is evidence of an intentional production. According to the court, quote, when a party makes a strategic decision that it later regrets, such as redacting a document rather than withholding it completely as privileged, it cannot later claim inadvertence to shield itself from the consequences of its own judgment call. Now, close quote. Looking at the facts demonstrating that Amazon produced documents multiple times with redactions, the court could not find that, quote, these disclosures were merely an accident, close quote, and that Amazon had waived privilege in the May 4th memo. As to the July 14th memo, the court found that even though the document was produced more than once, because it was produced without redactions, meaning there was no intentional decision to produce it in a redacted manner, it was not purposeful. And while the court does not say it, it was not inadvertent. So we've got May 4th memo as being waived because it was not an inadvertent production under Rule 502B. As to the July 14th memo and other documents, we now have to look at whether Amazon took reasonable steps to prevent the disclosure. The court looked at the process Amazon outlined and found that the process that Amazon used to review documents for responsiveness and privilege was sufficient to demonstrate that it took reasonable steps to prevent disclosure. So first two elements of 502B are met. But the court then turned to the final element of 502B, whether Amazon took prompt action to claw back IC31, IC40, and IC27. And based on the number of days that it took Amazon to claw those documents back, it found that Amazon had not met its burden to show that delays of 18 days, 49 days, and 21 days to claw back those documents were reasonable. Those were not reasonable timeframes under Rule 502B. As such, because all three elements of 502B must be met, the court found that Amazon had waived privilege in those documents. The court then agreed to conduct an in-camera review of the two documents that Amazon did not waive privilege on, the message chat in IC9 and the July 14th presentation. As to the chat, remember that the FTC identified this to Amazon as being potentially privileged. The court found that FTC had shown a good faith belief that some of the redacted messages were not privileged and granted in-camera review. As to the July 14th presentation, Amazon argued that it was created to seek legal advice, but the court noted that it was sent to 28 non-attorneys and 2 attorneys, and that 20 non-attorneys and 2 attorneys attended the meeting where the presentation was given. It also noted that the chat leading up to the meeting stated that the primary purpose of the meeting was not to solicit legal advice, but to get a plan in place for moving forward. The court agreed to exercise its discretion and conduct an in-camera review of the presentation to determine privilege despite those findings. Okay, what are our takeaways from this decision? Well, there are several. While Amazon is the party that's caught in the crosshairs here, this decision really highlights the complexity of trying to provide documents on a short time frame and to manage production in competing investigations. The amount of management required to ensure that all documents are treated the same is incredibly difficult. It is a very, very tall mountain to climb. And this decision demonstrates, though, that even though it's incredibly complex and a tall mountain, it is absolutely paramount for counsel to have their ducks in a row on how they are asserting privilege across multiple investigations. Now, please remember that I am Monday morning quarterbacking here on the case of the week, and I'm only working from the court's decision, not all of the filings that the parties have made in this case. That's how it works when we rely on case law for making arguments. And that's why we do it here like this on Case of the Week. This is an incredibly complicated situation for Amazon. Parties have very little leeway and a huge time crunch to produce documents in an investigation. And this case involved 3 separate investigations over a 2 to 3 year time period. The court's decision here basically requires that Amazon coordinate the documents from all 3 investigations, more than 1.7 million documents, and make consistent privilege calls across what are likely separate review teams and maybe even separate counsel. That's very, very difficult. But there are 2 important takeaways here. First, the court doesn't care how complicated it is. You still have to abide by the rules, and specifically here, Rule 502B. Amazon lost on 502B for 2 reasons. It intentionally produced documents with redactions and then tried to claw them back, meaning there was no inadvertence. And 2, it failed to claw back documents quickly enough. And here you need to focus on the number of days that the court said was too much: 18 days, 49 days, and 21 days with respect to each of those documents. In the scope of litigation, that number of days seems like nothing, but it was not timely enough in the Ninth Circuit. But the redaction piece here is also really important. According to this decision and the underlying cases cited by the court, when a party takes action to redact information to produce a redacted version of a document, that is an intentional decision that cannot be considered inadvertent. Rule 502D would cover that if applied, but Rule 502B does not. That means that your process and the management of privileged information is critical, and even more so in an investigation where Rule 502D will not apply. And that takes us to our second takeaway. This court found that 502D does not apply to investigations. It only applies to the litigation in which it is entered. And that makes sense given the language of the rule, but it also means that parties only have 502B to govern inadvertent production issues in an investigation. That's a critical holding and one to note if your firm is handling investigations. All of this means that when your client knows an investigation is coming, you need to prepare. Hold a special meeting about potentially privileged documents to ensure you have a process to identify all copies and mark them consistently. Tools these days will allow you to run near text deduplication, full text deduplication, lots of tools, lots of AI now that you can leverage to be able to find similar documents. It really should be a no-brainer with most of the tools that you have and likely the sophisticated tools they were using here for this investigation. You have to leverage those tools, but you have to know to take that step. And this decision tells you, you've got to make sure you're taking that step. Keep a log about all of these documents that you identify and run it against any future productions. If you have multiple counsel, make sure they are coordinating. You need one person in charge of all of these details or they will fall through the cracks as they did here. Apart from outright losing a case, there is nothing worse than the dread that settles into your gut when you realize you have produced attorney-client privileged information. The only way to prevent that is effective, efficient process planned in advance. The timeline of investigations is compressed to allow for creating that process and implementing it effectively. You need to do it beforehand. All right, that's our case of the week for this week. Thanks for joining me. We'll be back again next week with another decision from our eDiscovery Assistant database. Have a great week.